SMA as we call. I'm Chetali and I work as a senior researcher and a legal advisor with the Third World Network. And it is my privilege today to chair this webinar as we address one of the most pressing public health challenges that exist today, that is treatment for patients suffering from rare diseases. As we all know, SMA is a rare genetic disorder which, particularly in India, affects approximately 1 in every 10,000 births, and it imposes a significant burden on the patients as well as the families who are suffering from this rare disease. Now, I must tell you all that this number is highly underreported because according to a recent study that came out, India, India has a carrier frequency of almost 1 is to 38. So we can just visualize the number of children who are born each year with spinal muscular atrophy. Now, for SMA, if I talk about, basically there are three primary treatments that are available. Two of these are gene therapy treatments like called Zolgensma and Spinraza. Zolgensma is priced at approximately 17 crores Indian rupees, and the other one is Spinraza, which costs 4.1 crore Indian rupees in the first year, and then it has an annual maintenance of 2.1 crores. So there's another third drug which is there, which is a small molecule drug, which is called as Risdiplam, manufactured by a company called Hoffmann La Roche. Now, Risdiplam is priced at approximately rupees 6.2 lakh per bottle, and the dosage for the drug varies according to the weight of the and the age of the patient. So, if we roughly calculated the cost for this drug, which is a small molecule, comes to almost 72 lakh Indian rupees per year. Now, this drug has to be taken for lifeline. So the high prices of these drugs, if we like just I just told, combined with the severe non-availability, has left many countless families grappling with the affordability and accessibility of this drug. So we must also be cognizant of the fact that there was a study that was done by Dr. Melissa Barber as well as Knowledge Ecology International, where they'd come out that the price of this drug is actually to manufacture this drug Risdiplam is very, very less as compared to what the price is the company has pegged the drug at. So we must be cognizant that this drug can be produced at a fraction of the cost at what it is available currently in the market. Now, on 24th March this year, we had a very landmark judgment in this case in the Delhi High Court in a case called Natco versus Roche. So in this case, the government actually refused to grant injunction against a generic Indian company called Natco Pharma. Now, Natco has produced a generic version of this drug at almost 90% less, more than 90% less of the price at which Roche is selling the drug in India. So the price for per bottle is it's priced at approximately 15,900 Indian rupees, and you compare it with one bottle for Roche, which is 6.2 lakh Indian rupees per bottle. So you can see the price difference between the two, the generic manufacturer as well as the originator product. Now, the judgment, however, was appealed and it is now reserved in the division bench of the Delhi High Court. So, as we all wait for the judgment or the outcome pending, there is a lot of uncertainty around the patent enforcement as well as public interest and, most pressingly, accessibility of these drugs to patients suffering from rare diseases. Now, at the heart of this, we also have another very, very pressing issue, which is the Government of India's national policy for rare diseases. Now, this is a policy which has been envisaged by the central government, especially for patients who are suffering from rare diseases. The Government of India, under this policy, gives a one-time assistance of 50 lakh rupees to the patients suffering from rare diseases, one-time payment. Now, as I just told you, you look at the prices of the drugs for patients who are suffering from spinal muscular atrophy. If you look at the small molecule Risdiplam, the per year cost comes to approximately 72 lakhs. So under 50 lakhs, a patient may only be able to take this drug for 8 to 9 months. So for patients who like for patients who are suffering from diseases like SMA, spinal muscular atrophy, cystic fibrosis, or even a disease called Duchenne muscular atrophy, this amount falls abysmally small as compared to what the prices of these drugs are. So I think this is where today we will explore these dimensions, focusing on the implications of access, affordability, and the future of SMA care in India. So it is my distinct honor today to introduce you all to our two speakers today, two individuals whose perspectives and experiences illuminate the profound realities that are surrounding SMA in truly exceptional ways. So I'd like to introduce the first speaker, Mr. Anand Grover. Mr. Anand Grover is a senior advocate at the Supreme Court of India and he is a renowned human rights lawyer. He has served as a UN Special Rapporteur on the right to health and is also the co founder of Lawyers Collective. With decades of experience in public interest litigation, especially around access to medicines, health rights, and HIV/AIDS, he is currently representing a lot of SMA patients in the legal battle for affordable access to life saving treatments. I think through Anand's tireless efforts and an unwavering commitment, Anand has helped to navigate the complexities of law and policy, amplifying the voices of those who are often unheard and ensuring their needs are recognized within the broader healthcare and the legal systems. We are also very fortunate to have amongst us Ms. Purva Mittal. Purva is an assistant professor and a PhD scholar with a background in international business and marketing. As a young woman living with SMA, she intervened along with Seba, another petitioner, and a patient suffering from SMA, in the ongoing legal case to assert the fundamental right to life and advocate for introduction of affordable generics versions of the life-saving drug risdiplam that would help many people get the SMA treatments. I think Purva's lived experience brings a very authentic and a human dimension to our dialogue, reminding us that beyond every statistics and regulation, there is a story of perseverance, adaptation, and hope. So, with this, we'll begin our session today. I'll hand over the floor to Anand. Welcome, Anand, and the floor is yours to speak. Thank you.
Thank you, Chetali. I think you've explained somewhat what the issue is. I'll just go back to that. Now, according to some of the estimates, there are about 7,000 known rare diseases, and these are also referred to as orphan diseases. Today, we are talking about SMA, but actually, there are other rare diseases also, as Chetali mentioned, and they affect about 400 million people around the world. Now, most of these affect children. So, a rare disease actually defined in the US if it affects less than 200,000, 2 lakh people, and in the European Union, it is 1 in 2,000 people. Now, because it's a proportion of the people in Europe, the population is not very high. In India, even a small percentages can translate into hundreds and thousands of people. So we have, as Chetli mentioned, 1 in 33 under a study. So you can imagine how many people are actually affected by SMA. SMA, actually, spinal muscular atrophy, is because of a mutation in the what is known as the SMA1 gene, which actually leads to insufficient production of what is called the survival motor neuron protein, which is critical for motor neuron survival. If there's a deficiency in the SMN1 protein, it leads to muscle weakness, leading to progressive deterioration of muscle in the spine, and therefore inability to keep the back erect, difficulty in breathing, and ultimately death. Um, because large numbers of people cannot detect, the facilities do not exist in India for detection of um, SMA, young children just die and their parents don't know the reasons. Now, medicines for rare diseases are a major problem. As it is, medicines for ordinary diseases are normally developed, not discovered. There are two issues in medicine production: discovery, which takes place in the lab, and development, which are clinical trials. They actually are carried out by people who buy the drug which is likely to be patented, and they carry out clinical trials. Mostly they are developed, not necessarily discovered, by Western or Japanese multinational companies. Now, on the basis of, or the pretext, I would say, of high costs of discovery and development, the prices of drugs for ordinary ailments and particularly rare diseases are exorbitant, very high, and out of the reach of the common people. While European countries and to some extent the US, the provision of health services allows for drugs to be made available, including drugs for rare diseases. In developing countries like India and a large number of other countries, this is simply not possible. Uh, the multinationals claim that it costs them $1 billion to discover and develop a drug for which, for what is known as a blockbuster drug, which actually fetches them a turnover of 1 billion in the first year. Now, actually, this is highly contested. I'll come to that. Um, but in India, we've had a few issues, and let me just take you to that. Chetali has also mentioned that there is a policy which allows which actually facilitates by policy. There's no mandate, but the policy, the what is known as the national policy for rare diseases, and we are concerned with the last one, which is 2021, coupled with the notification note that was issued under that. The government provides for any rare disease a maximum sum of 50 lakhs for the patient to get the drugs. Now, that's okay for what are known as group 1 and group 2 diseases, because the cost of treatment for that is much less than 50 lakhs. But in group 3 diseases, which includes SMA, as Chetali mentioned, the cost of the drug, if you buy it in the market, is 72 lakhs approximately. Now that varies according to the weight and all, but we take a ballpark figure of 72 lakhs. Um, Now, because there is a cap for people who are suffering from SMA, there the money that is given to them by the government will be exhausted within a year. Uh, so what had happened was, in India there was a lot of litigation on this, and the primary litigation was in the Delhi High Court, not only relating to SMA but number of other diseases. And the Delhi High Court passed number of directions. And what they said ultimately, which the final judgment, which is challenged in the Supreme Court now, is that uh, the judge did not stick to the 50 lakhs figure for group 3 diseases. Pratibha Singh, the judge who gave the judgment, said that for group 3 diseases, including SMA, it would be decided on a case to case basis, and if necessary, the government would fork out more than 50 lakhs. So that actually, according to the government, was in violation of a policy. Their understanding of the law was that if a direction is passed by a court which is in violation of a policy, it's no good direction in law. So they challenged it in the Supreme Court, and the Supreme Court stayed that direction of 50 lakhs. Now, in the meantime, uh, what had happened was I appeared in that matter and I argued that the government has not done number of things, which I'll come to in a minute. In the meantime, one of the SMA affected persons, Seba, had filed a petition in the Kerala High Court. And what she said was that first of all, give me the drug within the 50 lakhs. And then once the 50 lakhs was over, she said, no, but I need more money because it's 50 lakhs is not sufficient. And the Kerala High Court, as an interim measure, directed that the money should be made available for drugs to be purchased through what are known as centers for excellence. That direction was given, but because that direction was given, which was contrary to the judgment, which was similar to the judgment of the Delhi High Court, which is known as Arnesh Shaw. The government, as they had challenged that portion in the Arnesh Shaw judgment, they also went against Seba's uh, direction by the Kerala High Court, and they also got a stay. Now, stay in the sense immediately they got a stay, but interesting things happened. Now, what had happened otherwise was that fortunately Hoffman La Roche, or Roche as we will call them, they had actually got a patent. They had got a patent all over the world and including in India, and they had also got marketing approval. The other two drugs do not have any marketing approval in India, as I understand it. But anyway, they are not marketed in India. So the only drug available for SMA in India is Risdiplam. Now, as it happened, luckily, I think for us, the SMA patients, NATCO actually also did the clinical trials for their generic drug and they were ready to market it. And because it was a patented drug, Roche filed a suit to get an injunction against NATCO because, according to them, they were likely to infringe their patent. They filed a suit in the Delhi High Court seeking an injunction. Now, normally, an individual cannot intervene in such a suit. It is a dispute between private parties, Roche and NATCO in this case. But what we decided, and this is the team of Third World Network, Gopa, Chetali, and others from Third World Network, MSF, Lena, and our Lawyers Collective team, we decided to actually intervene. And we did a lot of research and we found that we could actually legally intervene. In that intervention, we pointed out that, in fact, first of all, that in Pakistan and in China, which is obviously not to the liking of the government, the drug price had been negotiated in China by the government at $545 and in Pakistan in negotiations with NGOs for a price of $500 instead of what we had in India at about $7,200 per patient per year, a patient being about 20 kilograms. I mean, the price was substantially lower. And it was embarrassing for the government. And mind you, actually, the government should have intervened and said, please do not allow this injunction to go through because it will mean that generic production will not take place. Generic production has to take place under the National Policy for Rare Diseases of 2021. That is one of the mandates of the policy. But the government, as usual, did not do anything to ensure that generic production actually takes place. And if the injunction is not granted in the High Court, then NATCO can produce the generic drug and make it available, as Chitali said, 15,000 rupees, which is very, very low compared to others. Now, secondly, Roche, as usual, like all multinationals, made a claim that it's to discover and develop the drug risdiplam. No, they don't talk about risdiplam. Generally, any blockbuster drug costs them $1 billion, which is actually totally incorrect, because generally we know, and other studies have shown, retrospective studies show that it's not more than 50 million or $100 million. And there are three major studies in the US in this respect. I won't go there. But we were lucky in our case that we could actually get Dr. Jamie Love of Knowledge Ecology International to study how much money had been spent by Roche in discovering and developing this drug. So they took the US data for all the clinical trials and they actually made an estimate according to various pricing for the trials, and their figure was much less than $100 million. So all this hogwash of 1 billion was completely washed out, and they never challenged our study at all. Thirdly, as Chetali also mentioned, that actual cost of production, not discovery and development, which was done by Dr. Barber, is not, I will show that the drug would be produced at rupees 3,024 rupees. With all this in mind, and the point that we were making was that if you grant the injunction, very few people in thousands would get it, the drug. But if you don't grant the injunction, practically everybody would be able to get it with the National Rare Disease Policy with an amount of 50 lakhs. We were also able to point out that, in fact, the data from Parliament had been asked, the government had been asked questions by Dr. Shashi Tharoor in Parliament, and the fund, which is for rare diseases, was not ever spent fully. It was just carried on because it was not spent. So there was a lot of unspent money. So there was no need to keep this 50 lakhs uh, upper limit in every case. You could have easily used that money for people who needed it, like in the case of SEBA. So we were able to show that. And also we were able to show that the government can issue a compulsory license under the Patents Act under Section 92 or 100. Now, in fact, fortunately, in Seba's petition in the Kerala High Court, there were two prayers. One was that I need the money from the government to purchase the drug, and secondly, compulsory licenses should be issued. And in this case, as I say, we were fortunate that NETCO was ready to produce it. So the government could have issued the license in 1 minute and all the problems of the people would have been solved. But no, the government doesn't want to issue compulsory licensing primarily because, let me be very honest and bold about it, they are being pushed by the US and the European Union not to follow our law, which makes it very clear that in case of a scarcity of a drug, a patented drug, government should issue compulsory license, and under the TRIPS agreement, it is allowed, and under the Doha Declaration, it's very clear that the government should issue it. But the government toes the line of the US multinationals and the European multinationals. This is not now, been doing it for ages. So they don't want to issue compulsory licenses. So we had a position that the single judge, it goes to the single judge of the Delhi High Court, she rejected the application for injunction by Roche. Against that, as Chetali already pointed out, they went to the appeal court. The appeal court heard NATCO and Roche and heard us also. And now it has to decide. Now, what has happened also, the government of India, because they are worried that the Kerala High Court may issue a compulsory license, they don't want the Kerala High Court to hear it. They filed a petition in the Supreme Court to transfer Seba's matter to the Supreme Court. Now, all these matters are coming up on Tuesday. The 50 lakhs maximum limit, and also whether the matter for compulsory license should be transferred to the Supreme Court. We are going to oppose that. Uh, so, this is the present state of affairs. But let me tell you that the government has abdicated its responsibility in following the mandate of the law under the Patents Act. First of all, they should have thought of issuing a compulsory license, which is the policy of the government itself under the National Rare Disease Policy. Secondly, they could have intervened and they should have intervened in the Roche versus NATCO matter and said, please don't give an injunction because we need the drug for the people, our people, and they need it at a cheaper price. Thirdly, unlike Pakistan and China, they did never bother to negotiate in a proper way. The negotiations were carried in secret, and we don't know what price they have actually agreed to. But from other uh, data, we can infer that the price is still over 50 lakhs because in 50 lakhs that the government is purchasing, it cannot have the drug for more than a year. So the government, as I say, emphatically has abdicated its responsibility in providing generic drugs. This is Viksit Bharat, where we are supposed to be getting everything. We are not getting it because the government of the day is towing the multinational line, which are being pushed by the US, not only Trump, but also the European Union, who don't want compulsory licenses to be issued because they want to make more and more and more profits. Whereas when they actually develop and discover the drug, it's not even 100 million, the prices should be much, much lower. But forget that. Now, so we are actually poised in the next week in a critical stage. We will have the judgment of the Delhi High Court within this month, and also the Supreme Court will start hearing whether the matter should be transferred to the Supreme Court as far as compulsory licensing is concerned, and whether 50 lakhs maximum should be kept or not. But Delhi High Court has said no, it should be case to case basis, and we'll be arguing that. So I'll stop here because I've taken more than 30 minutes, I think. Yeah, 25 minutes. So any questions I'll be willing to answer. Thank you very much.
Uh, Thank you, Anand. Thank you very much for your insights today. In fact, you've given us a powerful reminder that real change often begins with a very sustained and determined voice. And we are really sincerely grateful for your tireless advocacy and the invaluable contributions that you made to this vital cause. Anand, we can take the questions after Purva has spoken. So I'd
Yes,
n-
yes,
like
yes, no problem.
Sure. I'd now like to invite Purva to share her experiences and a few words with us. Purva?
Right. Thank you so much, Chetali ma'am. Good evening, everyone. My name is Purva Mittal, and I wish I could say I'm here to share a success story. But the truth is, I'm here just to talk about the reality that breaks families apart, drains them of hope, and forces parents to watch their children fade away. All the while, the cure is sitting in a vial or a pill bottle, but out of our reach. I live with spinal muscular atrophy, and I'm here not just for myself, but for every family that's heard those three words and had their life split into before diagnosis and after diagnosis stage. If you have never seen SMA up close, let me tell you, it's not just a medical term in a file. It is a slow theft of movement. A baby who once kicked their legs with joy suddenly struggles to lift a finger. A child who once held their mother's hand can no longer grip it. Muscles they keep wasting and weakening. Breathing becomes a battle, eating a struggle, and sometimes even our speaking is taken away. Every parent of a child with SMA carries a silent countdown in their heads, wondering how many more weeks or months we have before our condition worsens. And all that while the medicine exists, the science exists, the possibility of a longer, better life exists, but still we are denied all of it. There are medicines like Risdiplam, Spinraza, and Zolgensma that can stop or slow this decline and provide us with a dignified life. They are nothing short of modern miracles, I should say, for me, for us, for our entire community. But here's the cruelty: miracles are priced like mansions. Like Chetali and Anand had already said, Risdiplam cost over 80 lakh every year. Spinraza cost crore for repetitive dosages. And Zolgensma 16 to 18 crores for one shot. It's just hard to imagine. Like my life has a price tag, and we all know the number, which is expensive and hard to afford. We can see the drug, but as we all know, we'll never be able to afford it without begging strangers on the internet or selling something we own. In India, this isn't just about cost, it's about denial by delay. Even if a family somehow raises the funds, they face endless paperwork, approvals, custom clearance nightmares, and sometimes outright refusal, and the time is lost. And with SMA, everyday lost is muscle lost, muscles that never comes back, not even if we get the medicine. In smaller towns, the picture is more harrowing. There may not even be a doctor who can diagnose SMA early. By the time parents even hear the name of the disease, precious months have already been stolen. The government announced a national rare disease policy recently, but with a cap of 50 lakh. On paper, it might sound like a great help. In reality, 50 lakh doesn't even buy a single year of treatment for most SMA families. For Zolgensma, it's less than 5% of what's needed. What use is a life jacket that only covers your arm when you are drowning? This analogy fits well in our life. Let me tell you what this actually means in real life. I've seen mothers who stop eating properly because they are saving every rupee for their child's next injection. I've seen fathers sell the home they built over decades but still fall short. I've seen children become weaker and weaker while their crowdfunding page counts up in lakhs, knowing crores are needed. I've seen parents watch a ventilator keep their child alive and still wonder if only we had gotten the medicine in time. But what is the worst part? We live with the knowledge that the world had the cure, but it was locked away behind money and red tape. I'm part of this legal battle today, not because I wanted to go to court, but because I was left with no other choice. When a system fails to protect its most vulnerable, it becomes our duty to push it, drag it, and force it to change. We are asking for bare minimum. We are asking for the basic, even when we should not have been in this situation. We want to remove the gap so treatment is actually possible. We want to make sure when the medicine is approved, it can reach to patients fast. We want to create a national registry and treatment guideline so no child falls through the cracks. To everyone listening, SMA may be called rare, but for us, it's everywhere. In our homes, in our hospital visit, in our nightmares. And I believe no parent should have to watch their child lose the ability to move, eat, or breathe, knowing there is a treatment. Just because the country we live in decide that our life wasn't worth the cost. I'm not seeking for sympathy. I'm seeking for equality and justice. We need policy that matches the urgency of the disease. We need to make sure that no family ever has to choose between financial ruin and their child's survival. It's an earnest request from our community, and I hope that it doesn't fall on the deaf ears. Thank you so much.
Thank you very much, Purva, for this poignant and moving things that you've said. I don't know, I don't have words for this, and for so candidly sharing your experiences and perspectives as a person living with the rare diseases. I think your journey highlights both the challenges and the strength within this community. I think it's inspiring for all of us to work harder for a future when no rare disease patient is denied care for reasons of cost or access. I think this is really, I think it rings a bell in our ears that it's high time that people think about it, the government thinks about it, that these people are rare, but still they are very equal. So we also have amongst us James Love from Knowledge Ecology International. James has been working on the area of rare diseases for a very, very long time. And we are privileged today that the entire team of Knowledge Ecology International is here today with us in the discussions. Jamie, there's been a request that in case you'd like to speak a few words on this.
Well, I think what's going on in India by the Lawyers Collective and by TWN and by MSF has really been amazing. It's such an important story, and it's a it's a it's a it's a it's a global shame that treatments developed initially with funding from charities and governments have languished in terms of their access around the world, and access is so unequal. It's a shocking outcome for such a terrible disease. And I think that the three groups that are most involved in this in India right now, and the patient groups and the SMA patient groups also, I mean, all of these groups in civil society that are working on this issue have done more than anyone else on the planet has to sort of advance this. And so I'm really, um, 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 it's a pleasure to listen to the webinar, and thank you for doing this.
Chetali, I want to say something, if I can, for 1 minute. I
Sure.
want to thank Jamie because he gave us the study of the cost that Roche have probably incurred in trying to discover and develop the risdiplam. So, it's very, very useful that we have that data. And I must tell him that, we are very grateful for that work, and also let you know that Roche have not denied the data that we produced because they had nothing to say, and they have not denied it, which is a very, very important thing, which we will be raising in the Supreme Court in the next week. So thank you very much, Jamie, for that work, as you have been doing it for years now.
Thank you, and I think everyone, all the SMA patients around the world will share in the benefits of the people in India if you're successful here, and I think that we have a lot of confidence in the litigation.
No, I can also tell you that NATCO, we will force NATCO also to export it where countries require it. So we have a good hope in this particular case, not necessarily in other cases, but we should exploit that to put the multinationals to shame on this. It's very important that we do that.
Thank you, Anand. And I echoes Anand's points on thanking Jamie for all the study and the data that he's provided us, immensely helpful in all our cases that we've been fighting at all the court levels in India. Thank you so much, Anand and Jamie. So the floor is now open for questions. So uh, we have a question from Abhishek Bhatia. So, Anand, this question is about a legal battle. I'll just read it through. Is the legal battle in India also including discussions on increased investment on R&D for medicines for rare diseases, in addition to making the generic Risdiplam available? What does India need to discover and manufacture more treatments for SMA? Also, could you share the situation of SMA treatment in other countries?
Well, I think, Chetali, you are the best person to share SMA treatment in other countries. But to answer the first question, uh, I don't think Indian companies are ready to invest the amount of money that is required for developing and discovering and developing new drugs. They are not ready to do that generally. One or two may start doing it, but it's not very remunerative immediately. So I think we'll have to wait for quite some time. But for for generic diseases, so generic drugs, India has a long history, expertise, and wherewithal to do it. As it's evident from the case of Risdiplam, NATCO were able to develop a generic drug very quickly. So we have that ability, and that's where we should actually focus right now. But unfortunately, the government is not doing its duty in encouraging local manufacture of generic drugs, which is their policy. It's shocking that they are not following their own policy. They didn't intervene in the Roche versus Natco case. They have not even negotiated a price like Pakistan and China did. So it's unfortunate. Um, Chitali, you can share the rest of the other countries what the
Yeah.
SMA situation.
So, actually, these are the three treatments that we are currently aware of that is available to patients. But the problem with India and the other countries, probably the developed nations, is that there it is covered under the government insurance or the NHS schemes or all those programs that are going on. But in India, unfortunately, we do not have anything except for the national policy of rare diseases. So, India is particularly placed in a very precarious condition as compared to how the accessibility is there. Now, from one of the patient groups in US, I just got to know that earlier Zolgensma was being run under the patient access program. Also, they were giving it to the children, but unfortunately, it has been terminated in US. So now the children who were waiting to get Zolgensma can no longer get it there also. To talk about the other new treatments, we've just got to know that there is a Chinese company that has gone to advanced stages of producing a gene therapy treatment for spinal muscular atrophy. And the good part is that the testing has all been done on patients from lower and middle LMICs, lower and middle income countries. To add to another thing, that the company has openly said that it is open to tech transfer to companies who can produce the drug in LMICs. So now the onus is on the government to look at how we can promote these gene therapy drugs, because if you talk about one of them is a curative treatment, so the gene that is problematic is completely replaced, so it's completely like curable. So in that case, the treatments are going on, and a lot of cell and gene therapy treatments are being developed globally. It's just that how fast the tech transfer programs can be done, and how what is the capacity of the government, especially in LMICs, to absorb that and tech transfer and give it to the patients. So now there's another question that's there is CRISPR-R treatment legal in India? If not, can we advocate for the CRISPR-R treatment to be made available in India? Anand, you'd like to answer this from a legal perspective. Is CRISPR treatment legal in India? Anand, are you there? Gopa, would you like to intervene on this point?
Um, I mean, for me, I think the question is that it is always legal, right? As soon as it is allowed by the regulatory agencies, right? I don't see nobody has approached the agency for a new treatment. As soon as it is there, I think once it is approved, it becomes legal, right? I don't think so. Any particular
Sorry,
barrier? Yeah.
no, basically, it's not illegal explicitly because any treatment in India would be legal provided, as Gopa says, it is gone through the regulatory process. Like NATCO went through the regulatory process to market it, but the government doesn't come in if it is patent infringement, like it is going on uh, in terms of the case of Roche versus NATCO. So there, Roche could sue NATCO for infringement, and it's up to NATCO to defend its future action. So it's not illegal by itself. They have to go through regulatory approval like they have to in every country. And if it's a patented drug, then there's a hurdle in trying to be able to produce it either by making sure there's no infringement action which succeeds, or through what is known as voluntary licensing, or through compulsory licensing. Thank you.
Yeah. So I'd like to just add that CRISPR in India is also permitted for research purposes. So we have another treatment like CAR-T treatment also. It's a little different from CRISPR because CRISPR is per se gene editing. But in India, there are a couple of guidelines that are there, not CRISPR, but the biosafety and the others are definitely taken into consideration when the technologies are implemented. So there is no specific law, as Anand just reiterated, prohibiting CRISPR in human somatic cells or for any therapeutic purposes. But of course, the guidelines need to be in place before CRISPR is done. We have another question from Dr. Siddharth Jain. Oh, sorry, it's a comment only. He says that no regulations in place for advanced biologics like cell and gene therapy, including CRISPR. We have not moved beyond regulations on biosimilars.
That's correct.
So to add to that, Siddharth, yeah, exactly. But I'd just like to point out that the government is currently contemplating developing guidelines on the cell and gene therapy, and they are in the process of developing guidelines. And the CDSU is currently moving in the process of developing the guidelines for cell and gene therapy. They are not yet in place, but
Chetali, I can see some questions
okay.
from me.
Any other? Yeah, okay. Anand, I'll just, yeah.
Yeah, I mean
Can
the
we make
real thing is,
amendments to?
yeah, can we make amendments to the patent law to make sure compulsory licensing goes through? It's not the law, it's the will of the government to act upon the law, which is totally in their favor, and also the Doha Declaration, which allows compulsory licensing. Unfortunately, the government doesn't have the will because they don't want to offend the multinationals as they are supported by the US or the Western countries. They don't want to offend them because they, for whatever reason, I can't fathom the reason. I think the right to live is more important. Right to live for Indian people is more important for the government than profits being made by multinational companies from other countries which are unconscionable. I would say they're criminal profits because they don't even spend $100 million for discovery and development, and they are earning more than 1 billion a year. So there's no need to fight shy. But I must tell you an anecdote. When I pointed out in the Supreme Court before that, the then Chief Justice, that you can easily issue a compulsory license. He said, but there'll be international ramifications. I said, a small country like Colombia has issued a compulsory license. Nothing happened to it. Why are we so afraid? So this notion of ramification internationally is actually bugging a lot of people for whatever reason. So it's more to do with the will of the government than the law, which needs amendments. Thank you.
Thank you, Anand. Anand, I have a question. So if NATSCO's generic production is fully upheld, what mechanisms you think can be established to ensure an equitable distribution and affordability,
No,
especially
I think they
yeah, for
sorry,
low
sorry.
income patients, especially for low income patients, because for some, even that product would be at a higher price. So what do
No,
you
but
think?
see, there we have to mobilize the patients group to actually make sure that whatever amount of money, maybe it's 15,000, 20,000, 50,000, that'll be well covered by the National Rare Disease Policy 2021 with a note. So 50 lakhs are available. They'll be easily covered by that, but we need to get everybody together, make sure that they are aware, they are knowledgeable, they're empowered to go and get that money or get the drugs to the centers of excellence by the government providing the money. So we must make patients and their families and their parents and guardians aware of that. That's one. Secondly, uh, the DNA testing technology now allows uh, to find out at a very early stage whether the person is afflicted by, say, SMA. That should also be pushed because the numbers are very high in India, 1 in 33. So I think that is also need to be pushed so that others who are actually going to be affected by SMA are detected in an early stage and drugs are provided for them, whichever they are available, either the Chinese, which is exported, or used through technology transfer. These are now treatable and curable ailments. So why should they not be able to live like any other person fully and develop their abilities? And a lot of them, because of the situation, they have devoted, they spend a lot of time studying, and they are very bright people. I've come across a lot of SMA children and adults, adolescents really, who are very bright. We should not lose those people because we are not spending money on the technology to detect them.
Uh, Anand, we have another question. Can Section 3 of the Indian Patent Acts be amended for the biological products in India?
No, there's no need for amendment. 3D, you're talking about 3 or 3D, I don't know what you're talking about.
Yeah, the
I think you're
question,
talking about,
Weber,
yeah,
you
no,
could be a little, yeah.
well, it's a slightly because it's a form, and each biosimilar is not the same form necessarily. So you may need an amendment. We need to think about it because a biosimilar is not a form like a crystalline or a gaseous form of the same product. So we need to think about a bit more why biosimilars cannot be also subject to the restriction under 3D. That's an issue that I think we need to think about more. Thank
Sure.
you for raising that.
Thanks, Anand. So we have a question from Faris. Faris is asking that, is there any study or register recording actual number of SMA or other rare diseases patients in India? So before going to Anand, I'll just answer that we don't have any explicit study. One of the major problems that we suffer here is registries which are old and obsolete, where they've not been updated, and we do not have any numbers. So as in the beginning, I said that the numbers are highly underdiagnosed. So according to one of the papers, we may be the SMA capital of the world. Same goes for a drug called for a disease called cystic fibrosis, where it is estimated that we have the highest number of patients at the moment in the world. So now if you look at our registry does not have the numbers. And as Anand pointed out, there is a new study that just came out. It's not a comprehensive study, but it only tells us about the carrier frequency. And it says that in North India, in India, 1 is to 38 is the carrier of SMA. So you can just estimate the number of infants that will be born each year with SMA. So what we are looking at is a very staggering number as compared to what is being reported. So that is one of the biggest problems that we are facing. And that is why I think that is should be a persistent demand that we should have a registry. Because of the non-updation or the obsolete registry, the exact number is not known. And that is why I think these people are getting pushed behind, because all the important diseases that are known, that cancer is there. So that is why they are more important as compared to the rare diseases. I hope that answers your question. Uh, I think there's no other question, so I'd just like to ask Purva something. Purva, from a patient's perspective, what support or intervention do you think is critical at this moment to improve access for SMA patients? Government intervention at the moment or support? Purva still there? I'm sorry, I think Purva has not been keeping well at all. So she's not there at the moment. Is there any? I think there's other questions as well. Yeah, there's a remark by Balakrishna Ramnath. Roche is asking us to buy Roche is asking us to buy two bottles at the same time, and they say that they will give three additional bottles free. The condition being that each free bottle will be given only when the previous bottle is close to getting over. This is worst condition as in case of SMA type 1 patient. God forbid the worst for the child and what they do with the free bottles. We need to ask Roche what they gain by doing this. So I think this is a bigger question on the patient access programs in India because we must look at the patient access programs for the rare diseases in a very larger perspective. Because they ask for three bottles free for two bottles, but then at the same time there are patients who will not be able to afford even two bottles. Considering the out-of-pocket expenditure that is has on and looking at the healthcare expenditure that a person in India has. So I think in that case, also I think in one of Anand's cases also it was pointed out that under the Roche patient access programs, they barely enrolled 57 patients. So this and at the on the paper of it, they say that they have a patient access program even for other diseases also, but it seems to be very hollow in promise. So I think this needs to be looked at a very larger perspective, and these issues need to be raised. I think there need to be a awareness about these because we need to push the limits of the patient access program also. Anand, you have any comments on this?
In the data that's supplied to us to the last question, it's about 1,000 patients that they are treating under their program, which is subject to a lot of conditions, as you have pointed out. So they're not enough, but I think some of them are treated free also. I don't know because we don't have that data, and I suspect that they actually make sure that some people who are very active, their children are treated very liberally and given completely free access. And I can't tell you the reason because I don't want to publicly disclose it. They don't want them to litigate against them. Let me put it that way. So they are giving some drugs completely free to buy over patients so they do not litigate against Roche.
So, if is there any other question?
Chitali, I want to say something that I think we should have a larger meeting in Delhi and call other people and with the activists of the affected group like Purva, um, um, we get other people so that larger numbers of people of the general public come to know of it. We can organize such a meeting with groups which are working on other issues. They have programs, so they would like. I think it'd be good. I can arrange one meeting, a general meeting for a lot of people, and make them enlightened about it. That so they support us, because we can't restrict it only to um, the activists on rare diseases and the persons affected. We need to go much broader, and that can be done.
Thank you very much, Anand. That's a wonderful point. In fact, we've been thinking, and I think if Gopa wants to add something on this, because this is a very pressing issue, and as you rightly said, it should not just be confined to only the few organizations who are working and the patients. It's the larger community and people who need to be aware of the rare diseases. So, Gopa,
No,
you'd like to add
yeah,
something?
yeah, yeah. Anand, it's a very good suggestion. So basically, all the rare disease, the stand of government is that they do not want to spend more than 50 lakhs. That means 5 million Indian rupee per person, nothing beyond that, right? And this amount is not enough to treat even for 1 year for SMA, CF, DMD, etc. And at the same time, government also saying that they are not ready to do anything to bring down the cost. I think we bring together all these people who are suffering from lack of access due to this kind of policies or this kind of approaches of the government. We bring together, and it's a joint fight actually, and it's a very good idea. So we are ready to
I mean,
help you to pull through that meeting. Okay, whatever we
yeah.
would like, we can
No,
do
no,
that in
it's
that direction. We are
we
ready to do
can
that.
do it at either at IIC or somewhere like Habitat, and actually get the general public who are more conscious, like lawyers, socially active people, not activists. They need to know more about it, and they are influential people. So we can do it through the leaflet or the Lawyers Collective or whatever, including Third World Network, MSF, whatever, so that we have a meeting where we get other people also involved, make work and now the issue is alive with the matters in the Supreme Court and in the Delhi High Court. So
I
it's a
think we
good
should
time
do
to
that.
have
We
it.
should, yeah, we should do that at the earliest.
Yeah,
We
we
are
can
ready
do it
to,
either
yeah,
in
yeah.
next month or in October. October is difficult
Sure.
because there are two holidays, Dussehra, Diwali. So either in September or November.
Uh, thank, thank you, Anand. We'll discuss with it and then we'll share the details with you.
Sure.
So, yeah. If there are no other questions, then we'd like to close this session. And I'd like to thank everyone for the discussions today. I really sincerely want to thank both our speakers, Anand, whose dedication to the legal battle surrounding rare diseases has been nothing short of inspiring. I think through his unwavering commitment, he has not only championed the rights of individuals affected by rare conditions, but I think he's also shed light on the pressing needs for legal reforms, the intellectual property things, and the greater awareness. And a lot of thanks to Purva. Her journey highlights the challenges and strengths that we need to fight for patients suffering from these diseases. I think both the speakers have embodied the courage and advocacy that is essential in advancing in the understanding and the support and the meaningful change for people who are affected by SMA. Their contributions, drawn from personal and professional realms, have enriched this discussion in ways both inspiring and invaluable. Thank you for reminding us what is truly at stake and motivating us to be a part of this challenge, Anand. Thank you so much. Purva is not here, but I would really like to thank her for this. Thank you for a wonderful audience and for the invigorating discussions and the questions that we had. Thank you very much, Jamie, and the entire team of KEI and MSF, Christoph, who've come here to attend this session. It's really inspiring for all of you to be here. Thank you so much. Thank you.
I see Shahina is there, Seba's aunt.
Yeah,
She's the one of
yeah,
the. Thank you, Shahina ji.
thank you. Thank you, everyone.
Thank
Thank you.
you. Thank you.
Thanks.
Thanks.
Thanks, Gar. Thanks, Gargia. We can close the meeting. Thanks.
Thanks, everyone. We'll be now closing the meeting.